Hi there. I'm Justin Plummer, one of the attorneys here at Cheryl David's office, and I welcome you to our webinar series on estate planning and elder care law. We're going to try to cover a lot during this time period, but we're going to try to keep it to about an hour, and I'm hoping to have some question time allotted for the end. So what I would say is, before we get truly started, there's going to be a chat box down below, and if you have any questions, thoughts, comments, please insert those into that area while I'm speaking, and I'll try to carve out about 5 to 10 minutes to answer questions at the end of this process. There is also going to be a link that should be there for appointments that you can sign up for, and we'll intermittently put that in the chat during our process. So the best way that we can get started is probably to watch a video.
I got a dreaded phone call. My sister was in intensive care. We made it up there and she passed away. She had contracted bacterial meningitis. And the thought that I could lose somebody so dear to me so quickly was devastating. And it made me rethink absolutely everything, but especially my career. Realizing that what we went through with my sister was something that happened to people every single day. And I thought if I could be of help when people are going through that horrible time in their life and make it a little bit easier.
My husband, Wiley Harris, passed away in 2017. And then I realized I needed some help. The human aspect means a lot to me. And some places are business, business, business to the end of day. But they have been very conscientious and they have led me into the right direction. She got some great people working with her. I just have full faith and confidence in the staff.
It's very special to me that we help families, but we're also a firm that's comprised of a family. It's myself, it's my daughter, Blair, the other attorney that I work with, Justin Plummer. He's like family. The clients respond to this family atmosphere, and I think that they can feel that we really care.
Well, I wanted to ensure that my family would be taken care of.
Also first met Cheryl through his mother, who came basically to live with us after his father passed away. And so we would try to make it simpler when it came time for us to deal with her.
After we met Cheryl, she gave us the ropes, and transfer of the estate took a matter of weeks.
But no one wants to talk about death, but it's something that's inevitable for each and every one of us. It's smart to come in and have a conversation, because if you don't have a conversation, you're not protecting those that come after you. We recommend that you come see us at the law offices of Cheryl David, and we'll sit down and we'll listen to you, and we'll try to come up with the best plan that we possibly can.
All right, hopefully that gave you a little bit more insights into our firm. Just to give you an overview again, I'm Justin Plummer. I'm one of our estate planning attorneys here at our law office. It's myself, my law partner Blair McClanahan, and Cheryl David. All we do is estate plan and elder care law here at the law office, and otherwise we probably can refer you to some other people, but that is all we do, in that we're a specialty firm. So hopefully you're going to gain some knowledge today about some of these comments or aspects of estate planning that you've been wanting to learn about, and probably even more than that. So hopefully we'll do a good job of not creating more questions than giving answers. So again, just as an overview for ground rules, please jot down your comments in the chat feature and ask questions in that Q&A section, as well as look out for that Calendly link so that you can make your appointments with our office. Again, a welcome to you. We've been doing this for about 35 years now at our law office. myself and Cheryl David are board certified specialists in estate planning. Blair handles our estate planning, but also elder care sections of the firm. And she is board certified in elder care planning as well. To that end, we help many people across the state of North Carolina with their estate plans, from Boone to Currituck County, as I like to say. We do it all. And so we encourage you to, hopefully this resonates with you and your families. And we just hope that you can learn something from it. And also, if it pertains to you, hopefully you will act as well. So a lot of people come into our world because they have seen families torn apart. Their plans may not be working as they wanted them to. They want to avoid death and taxes or nursing home expenses. There's a lot of reasons that people don't plan that I've found over the years. And just some of them are here on your screen. Procrastination, a lack of knowledge, complex legal issues. Quite frankly, it's just too much information, and it's really easy to kick the proverbial can down the road on these types of situations. And that's not good, because I think most estate planners will let you know, and I don't think you need to be an estate planner to understand this. We're not promised tomorrow. So if you don't have a plan already, it's always the easiest thing to, again, put off until tomorrow. And unfortunately, sometimes tomorrow doesn't come. And then we see these situations which inevitably usually lead others to say, well, I don't want to end up like so-and-so. So I'm going to get my side of the aisle clean and do my plans. There's continuous law changes in the law as well. And I think the internet has not done us any favors in that regard. So be wary about, you can research on the internet and what you can find out there, because this is really the area of law that combines many different aspects: real estate, marriage, family law, tax law, all these different types of areas of law kind of culminate when a person passes away, because they certainly have different situations or assets. So again, we talked to a number of clients over our years of doing this, and I find there are some pretty substantial ones that keep reoccurring over the years. So I'm sure that nobody that I've talked to wants their hard-earned wealth that they have accumulated over the years to go to government oversight or court oversight being involved when they pass away. A lot of people want to avoid unnecessary taxes, fees, headaches of court costs, and just the usually the logistics of what probate court entails. And we'll talk a little bit about that in a second. A lot of people nowadays also have to see their parents or themselves facing nursing home or in-home care. And that can be a sizable amount of somebody's estate, which on a long enough timeline can really bankrupt anybody. I don't care how much money you have. So they want to protect against that. For my younger family members, what about if you have minor children? You need to have at least a will that dictates who would be the guardian of that child in North Carolina if you and your spouse or their biological parent should predecease that child. I don't think anybody wants the court to be the one that decides who is going to be the right person to be a guardian or parent or manage that person's money. Now, certainly I wouldn't be talking about my family here, but I know there's many others out there that possibly don't get along in certain scenarios. And I often find that money and death change people, unfortunately. So one of my favorite quotes is, you never know a person until you've shared an inheritance with them. And I unfortunately get to see that day to day. And so oftentimes, if maybe brother, sister, other family members aren't getting along already, maybe before death, certainly without a plan to kind of navigate what that looks like down the road, it's certainly probably not going to get better without one. So at the end of the day, I think about this. Estate planning, it takes your goals, what's valuable to you, what do you want to do, what do you want to protect, how do you want to leave your legacy? And certainly this is your opportunity to tell the state of North Carolina what your wishes are, because I promise you, as we'll talk about in a second, they have a plan totally for you if you do not have one for yourself. So this is your opportunity while you're alive and well to make these documents and your choices. I feel like the best way to go about this and talk to individuals about this is through an example. We're going to take a journey with Bill and Mary Jones. Let's say they're a North Carolina couple in their 60s, and they have an estate that's worth maybe 700,000 or so. Let's say that's a piece of real estate, some retirement, cash savings, brokerage, what have you, life insurance. Bill and Mary have 2 children, John and Susan. Okay. Well, let's take a look at what Bill and Mary's planning options are as far as their estate is considered when they pass away. Okay. Well, certainly you can spend every last dollar that you have. I've never seen somebody get to that point. I've seen somebody get close, but that's always everybody's favorite joke, is that they're going to spend they're spending their children's inheritance right now. Never seen it happen. Maybe one day. You can die intestate. That means that you have passed away without a will or a trust document in place. And what that means is that it's going to default back to the state statutes as far as who's going to get what and who has an opportunity to be in charge. I can tell you right now, that's not always the best case scenario, especially if one of your children has, say, spendthrift ways, substance abuse, or maybe in another fact pattern, maybe it's a second marriage. Maybe that would put a then surviving spouse maybe co-owning some property with stepchildren in that regard. And that's not always the best case scenario either. You could always put things in joint tenancy. I always caution people from doing this because this can, especially where real estate's concerned, can really affect your cost basis in certain properties if you gift that or add your children or another person to your deed just generically. So you need to be careful about how you do that, as well as putting them on joint accounts and items like that. Those are also seen as their assets at that point in time. So if they later get divorced, that could be an issue down the road. If they were to clean out that account, that certainly would be their right to do that because they are certainly a co-owner on that account. So many other ways and reasons lead us to different and better options in that regard. We're going to talk about wills, trust here in a little bit, but just as a sample, everybody, I think, as a minimum, needs a will. Okay, that's going to dictate who's in charge and who's going to get what with the court when you pass away. However, wills go through court. Wills are a ticket to the court process of probate. Just because you've signed a will does not mean that everything's taken care of. It certainly evidences your wishes for those things to be done, but that is going to be processed through the court and done that way. For many individuals in North Carolina and across America, trust work is a better way to go about their end of life plan because it's more malleable and you can do a lot more things with it. Protections for beneficiaries, getting outside of probate, and planning for a couple different items in that regard. So again, we're going to take a journey with Bill and Mary, and just to let you know from the outset, it's not going to go well for them, unfortunately. We're going to take the vantage point that they don't have any documents. So no wills, no trusts, no healthcare powers of attorney, no financial powers of attorney, nothing of that nature. Okay. So let's say that Bill has a stroke. Okay. And if Bill has a stroke and then recovers, but is disabled and is incapacitated and can't make legal decisions for himself, if there's not a power of attorney in place over finances and healthcare, that family is going to be going to do a guardianship proceeding at the clerk of court. Likely it's going to have to involve an attorney. Most times that is the case. There might be some guardian ad litems that have to be appointed as well. And what that is a guardianship is the court deciding who is going to best be the person to take care of a person's mental, I should say their financial and healthcare affairs for them. I can tell you from a personal standpoint that I got to see my grandmother go through this, unfortunately, and it was very disheartening. And I can tell from her standpoint and my father's standpoint as her sole only child that was applying to be the guardian with the court. It's very frustrating. And as you can see here on your screen, there's oftentimes a chance that a lot of medical history will be disclosed. It's humiliating. You kind of have to drag this person into court to have to testify as to who that, you know, and other people's evidence as to who they might want in those certain positions. Not to mention, that's just the start of the quote unquote fun in that regard. You're going to have to account for the rest of that person's life while they're incapacitated. Yearly accountings to the clerk of court as far as every down to every penny of what their money is going towards and what it's used for. And that's yearly. That's every year with the clerk of court. A lot of personal information is disclosed. And again, between court fees, attorney's fees, accounting fees, and ongoing nature of the process, that can be totally avoided with 1 or 2 documents in that of a financial power of attorney and a healthcare power of attorney. Now, let's talk about when Bill passes away. I want to say this now. Most of the time, if you're a single individual, that will be when there is a probate proceeding, okay? I won't say that it's a rarity that when the first spouse passes away that there has to be a full probate proceeding, but oftentimes there's a smaller process for when a surviving spouse is still there that can be completed with the court. So I just want you to know that when I'm talking about a probate proceeding here, it usually is on the single person's passing or upon the second spouse's passing. So what I'll say is this: I handle our probate and trust administration department here at the office. I do this every day, and I would highly recommend not having to go through probate. Again, probate happens if you don't have a will, or even if you have a will, the court is going to oversee that process and make sure that all of the items that are legally necessary to administer that person's estate get done. What that means when you have government interaction in that manner is that it's going to probably be at least a year process. And then you're going to have a lot of items to do for your executor during that time period. You're going to have to open up the estate with the court. That might take a couple weeks to a month or even longer to get those letters necessary to take to the banks to gain access to the money to pay final bills, to pay funeral costs, those types of things. Within 90 days of the opening of the estate, you're going to have to run a notice in the local newspaper as to noticing creditors who that person may have owed money to prior to their passing, or on the flip side of that, who may have owed them money. During that same time period, within 90 days, you're going to have to appraise all assets and inventory the deceased person's assets and put a value on them for the clerk of court. From that, the court takes $4 on every $1,000 of assets that comes to the court. Now that's capped at $6,000, but that can be quite a sizable amount. Not to mention that notice in the creditors can be a couple $100 for the local newspaper. It's $120 to file to get the estate open to the court. As you can start to see this cha-ching of snowballing of money. Along with this, once those items are done, you're going to have to work with institutions to get those assets transferred, liquidated, placed into a holding account with a local bank, a estate account. A new tax ID number will have to be obtained. There will need to be a final tax return for the deceased done as well, and possibly a fiduciary tax return if there was interest or gains, losses during that time period. So most of the times I talk to people about this, yes, it's a year-long process, but that's only half the battle. It can be also a very expensive process as well. I know that most of individuals like myself who practice in this area, attorneys take either a flat percentage rate of the estate to help individuals through this process for that time period, or some other ones do an hourly fee, and that can be, anywhere from $200 an hour to $400 an hour, or 2 to 5% of the estate to do that job. You as an executor, the executor also gets paid from the clerk of court as well based on those assets. So you can start seeing this is quite a sum of money. It's hard to say for most individuals what that's really going to look like at the end of the day, because everybody has different assets and no estate really looks the same. But on typical estates, you stand to lose anywhere from 2 to 5% going through the probate process or more of your estate. So keep that kind of number in your head as it applies to your own estate, is what that might be. Let alone, this is also public to anybody. You can go and obtain anybody's file at the clerk of court's office from the estate and see who's inherited what they passed away with money-wise, and who got it. Let alone, if you own property in many different states, you may have to do a probate proceeding in each one of those states that you have real estate in. So if you have a timeshare in South Carolina, or maybe Orlando, Florida, maybe you own a lake home in Tennessee or Smith Mountain Lake, Virginia, and you have your residence here, you might be going through 2 or 3 different probate proceedings at the end of your life, depending on where you own real estate in, because that state's own state statutes govern that property. And it just depends on how things are titled when you pass away. The good news, and I'm always a fan of giving some good news instead of always bad news, is that North Carolina no longer has an estate tax. Federally, there's an estate tax in 2024 of $13.61 million, and married couples get to double that. Okay, so I don't meet that many individuals that have that certain tax threshold any longer. It's jumped up and ballooned up over the years. Wasn't that many years ago. It was a couple million, then 5 million, and it's kind of jumped up. We certainly can still help those individuals that have that kind of wealth, but oftentimes I like to joke that that's the best problem you'll ever have in the world. So I will say this, that those individuals need to be on the radar, that if Congress does not act prior to the end of 2025, those amounts are scheduled to come back down to around 5 million and to be indexed with inflation. So it'll be a little bit over 5 million or so, but that's a big concern for some people, because when those jumped up, you probably didn't have an estate tax, but they may come back down for the first time. So we'll see. A big concern outside of probate is, what if after Bill passes, and what if Mary remarries? Okay, what if she gets remarried and all of a sudden they don't do a new estate plan, or maybe they create just a simple estate plan where you leave everything to the other spouse? Well, if it's not written up in the correct manner, I have to tell individuals all the time that sometimes you're going to be possibly cutting out one side of your family. Just depend on the wording of your will. So if Mary remarries Tom here, and then Mary passes away and has an estate that everything goes to Tom, well, everything probably is going to get split up by Tom's children, and Mary's children might be cut out of it. So it's very important to think about divorce and remarriage aspects for your estate plan while you and your spouse are still alive. Now, at this point in our situation, Mary has a whole estate, about 700,000 or so. On average, a surviving spouse is going to live about 7 years or more after the death of their spouse. Family assets traditionally over time double about 10 years. So by the time that she gets to that point in her life, 10 years later, if Mary then has Alzheimer's, she might have substantially more money, but it might be taking more money to keep her up. If she has to end up in a nursing facility with an average stay of 2.4 years or so, maybe longer nowadays, we are living longer with modern medicine and technology, that's a concern of how we're going to pay for that. So at the end of the day, when you're thinking about these things, let alone payment for costs of care, what if Mary is then with Alzheimer's, doesn't have one of those powers of attorneys again, like her husband did? Well, at that point in time, who are they going to appoint as, if there's 2 children, what if there's infighting there about who thinks they have mom's best interest at heart and who's going to be that power of attorney or guardian? At that point in time, that's 2 guardianships they've been through, and probably at least 1 probate, if not 2. You can finagle these numbers a little bit, but you can start seeing the true cost of care for nursing home care, of what that might cost, the probate fees, guardianships. You can stand to lose a substantial chunk of your money no matter where you are with your own estate. Let alone after all that, usually with probates, that money is flushed into those children or whoever is going to be inheriting, that goes straight to that individual. And so God forbid they have tax liens or they have creditors after them. Maybe they're in the middle of a divorce proceeding. Those aspects tend to raise the question, are each one of those beneficiaries ready to have that kind of money allocated to them? And depending on the name and age and who they are in their life, that might be a different answer. I think most people are often afraid. I know I am as a parent, if my child is married to somebody and when those inherited funds get commingled, if they pay off the house or student debt or whatever, or they just put those inheritance in a joint checking account or brokerage account or whatever, there goes half of that money in a later divorce if they later get divorced down the road. Again, we just talked about this. If John, their son, has serious issues, maybe he's a spendthrift, money goes out of his pocket before it gets in there, that money can be attached to, because it's going straight to his ownership, and he might not see any of that money if he's got enough creditors out there. So I think we've talked a lot about this, is that obviously it's going to be a lot harder if you have no estate plan at all, no powers of attorney, no at least will or trust in those situations, and you're just going to be hemorrhaging money down the road, as well as your family's assets as well that you want to leave them. So obviously we're talking here about there's a lot of different ways to handle estates and planning, okay? So let's talk about one of my favorite tools to work on this aspect is the revocable living trust. So let's talk about how it works. Really, when I talk to people one-on-one in the office, sometimes I often tell people, I think of a trust much like a briefcase, a piece of luggage, a bucket, a box, anything that's portable that you can take with you anywhere. And to step back, what really matters when you pass away is how assets are titled, okay? If you create a trust, which is in essence a will in a contract form, you're still in a trust dictating who's in charge, who's going to get what, but maybe also some terms and conditions around how they're going to receive that money. The idea is by then taking your assets that you have, say the deed to your home, checking, savings, brokerage, life insurance accounts, anything that has title to it, okay? Vehicles, mutual funds, stocks, bonds, what have you. If you take those assets and place them in the trust name, retitling them, what in essence you're doing is fast forwarding through the probate process during your life. And I'm a visual person, so I really enjoy this slide because this shows you that basically what you're doing is you are placing everything into the family trust name. And by doing that, going back to our analogy of the briefcase or luggage, if you should get sick, well, then your spouse, if you're married, will then manage that money for you. If both of you as spouses are incapacitated, you're probably figuratively speaking, handing that briefcase or luggage off to your next person in line you have chosen, maybe a child, maybe somebody else, to manage that money while you're still alive for you. If you both have passed away, upon your passing, what you're doing is passing that off for somebody to distribute out per the terms of your trust at that point in time. The name of this game, though, is that you're doing all that passing off without any court intervention at all. And because you have set up this stuff properly, and I will go into what that means properly in a second, that means that there's no court involvement down the road, and that once there's a death certificate issued or incapacity, that handoff can take place. Now, I don't want to get bogged down in the minutiae here, but you are wearing 3 different hats when you are setting up this trust. And by wearing all 3 of these hats, you are going to have business as usual as far as your assets go, okay? And the trust, setting up a revocable trust is not giving up any control over your assets or any functional day-to-day operations over them. You can add stuff to your trust as far as homes and accounts, that sort of stuff. You can sell them, certainly. All you're going to do to sell your home with out of the trust is to write your name and comma trustee. It won't be that much different from a typical closing. But the idea is really because you are doing this work now, you get to fast forward through that probate process and guardianship processes during your lifetime so that your children or beneficiaries otherwise will have it much easier and without court involvement in that costly figures that we saw before. So we've talked about that while you set it up, you're in control. Again, the property taxes, you will file your taxes every year the same way. You can still have your typical bank accounts that you do. There'll be no need to like reset up new accounts and that sort of aspects of it. It's a change in title ownership, if you will. And through that trust, we can then take a look at Bill and Mary and let's give them a do-over for their situation. Let's say they had that trust that's fully funded or has all the assets connected to it. That's the better word that I like. And that's a very important aspect. Let me say that is that if you're going to have a trust, it's not worth having a trust that doesn't have everything connected to it. So maybe some of you folks who are watching already have a trust. It's very important for you to go back and see what does our bank account statement say? What does the deed to our house say? You have to make sure that all those assets are in your trust or it's not going to work because your trust can only control what it's connected to, okay? So back to our scenario, if Bill has that stroke, there's not going to be any guardianship proceedings at that point in time. You're going to have that power of attorney for finance and healthcare that's already dictated that probably his spouse is going to make those decisions without any court intervention. Since everything that they set up is in the trust name, there's no court intervention that will happen when Bill passes away. Everything is in the trust name and his wife is in charge of it. That way there's nothing to do. There's no trust administration even or estate administration, dependent upon some tax issues or whatnot. But for the most part, everything stays business as usual. Again, on Mary's situation, there's no need for that guardianship proceeding because she already has those powers of attorney that have appointed her children, and probably in her case, Susan, in that particular scenario as her guardian or power of attorney, excuse me. Again, at her death, there'll be no need for probate because the trust is holding everything and there's no titled property in Mary's name that has to go through probate. So you avoid all of that. It's a private administration at that point in time, and there's no multiple probates. If you have land in different states, the trust can hold that as well. So that eradicates the need for additional probates in different estates. If you have assets in the trust, they're much like a tube of toothpaste. If you want, you can certainly give, if your children have good heads on their shoulders or beneficiaries, you certainly can give them those assets outright. There's nothing stopping that. But oftentimes it's better for them to have their trust share be like a tube of toothpaste, as you can see here, that they can take a little bit out as they need to, but for the most part, they keep that under the trust name. It's still theirs to access and have access to and to spend. But by doing that, it gives some divorce protections for Susan, let's say, if she's going to be getting divorced down the road, because she keeps it under the name of the trust after her parents pass away, it's not seen as her direct asset. And while she can utilize it for her benefit, it's not seen as hers. And that's how you get divorce protections for that inheritance for Susan down the road. Or maybe somebody in your family or a child of yours that might have that situation. John, well, let's continue to talk about that. So if Susan then has a divorce proceeding after her parents pass away, that money's safeguarded. Now, for John, we may have to have a century trust for him, basically having a neutral third party that's over his funds so that he doesn't say spend them all or doesn't have all those tax liens and creditors attack that money, that it can be doled out to him directly over time. But since it's not going to be tied to him directly, that's how you get around that issue. And so if we do end up talking about that, make sure that's an issue you bring up with one of the attorneys, because that does take a little bit of tweaking under the trust to do. So again, going back to the toothpaste analogy, by keeping those assets in the tube of toothpaste rather than just giving him everything at once, it's the drip, drip, drip mentality that he can still benefit from that money while still having creditors attached to his assets personally. I will say this too, if you know of somebody, or maybe your family has somebody that's afflicted with special needs issues and they're on SSI government benefits, it's very important that you do some additional planning. Let me say that again, because it's very important. You need to have a estate plan that really focuses on that special needs and supplemental needs trust provisions that are likely needed for those government benefits. If somebody is on benefits and inherits money, well, the state is going to want them to be repaid for all the funds that they have paid out on their behalf over the years. So there is a situation where somebody could say, be receiving $1 million that may not receive any of it if they were on benefits, because they might already owe that much back to the state. So it's very important that you plan for those things. So again, with the revocable trust and all the other aspects of like the powers of attorney and all those items, those are what most individuals I think could really stand to benefit from, because you have every one of those situations pretty much accounted for. Let me take a second to talk about long-term care here as well, and Medicaid planning. Now, this will be additional planning to what we've been talking about with a revocable trust. A revocable trust will not give you protections over nursing home. Just wanted to say that. The power of attorney in our practice is one of the most important aspects of our plans. We have an enhanced power of attorney for finance that includes special gifting language that is necessary in order to protect people's assets down the road should nursing home care become an issue, okay? When it comes to these types of things, obviously you can spend all the money that you have on the cost of care. I think the going rate is about 5,000 to 11,000 locally, just depending on the type and level of care you need. It's certainly depending on what city you're in, and certainly other states, it can rise and fall in that regard. But they certainly will cash your check, and they will continue to do so. If you have long-term care insurance, that's great. For us as estate planners and elder care planners, it gives us a longer runway for planning, a buffer, if you will. But not everybody has that, and that's fine. I encourage you to take into looking into long-term care if it's affordable to you. And they have some policies that most anybody can afford that give you some sort of protection there. If you're a benefit, or for your spouse or yourself as a veteran, there are certain benefits that you can receive if you've had certain experience in the field of during wartime, and as far as serving in the military during certain time periods, there are certain parameters around that. So I highly encourage you to talk to your local VA office. And of course, you have Medicare and Medicaid. It never fails where I hear somebody say that, oh, I've been paying into Medicaid or Medicare all my life. That'll take care of it. And I just cringe, because Medicare is only going to pay for your care for about 20 days. And unfortunately, at that point, the doctor's probably going to write a little letter that says, this person has gotten better, or if they're not better, we need to kick them out of here. And those are the only time periods they're going to pay for, okay? At that point, it will be on you to private pay if you still need long-term care or in-home care at that point in time, which leaves then Medicaid. Now, Medicaid, let me dispel some myths here. You do not have to give all of your assets away or spend them down, to qualify for Medicaid. Medicaid is a complex set of rules and statutes that work to help give individuals under certain income levels benefits. You cannot just artificially impoverish yourself in order to get those either. You can't just say, I'm going to throw my child's name on my deed and get that out of Medicaid's 5-year look back period. You cannot just put them on a joint bank account or give your children all of your money and say, look, I'm impoverished, I need Medicaid. That being said, North Carolina allows us to protect real estate, even if somebody is already in a nursing facility. So for a lot of times, if you have a power of attorney, that document changed in North Carolina in 2018. I highly encourage you to take a look and see if the gifting language section in that has certain abilities to deed property or make gifts between spouses, because a lot of that language is what we need. And I would say most people that we encounter that haven't been to an elder care planning attorney before have that issue and don't have the right language. And of course, if you were then later incapacitated, we cannot later do a document at that point in time we would need if you're already incapacitated legally and ethically. So at that point in time, we have to tell a lot of individuals there's not a lot we can do. So it's important to have the right tools in our tool belt to help you down the road. So what to expect from working with us? If this has resonated with you and you want to work with our firm and possibly create an estate plan, typically our firm, when we set up a trust, it's 3 different meetings, okay? I like our firm in the sense that we have set fees. There's no surprises. We design a customized estate plan for you. And it will take into aspects a lot of different areas of your life. So your real estate, marriage, family dynamics. What are your goals? How do you want to see this money distributed? Maybe it's not all at once. Maybe we have to structure it in certain ways. And we give you 2 months to make free changes after you sign it, because inevitably somebody may go on a vacation, go visit a family member or something, and come back to us and say, gosh, I'm glad I did that because I need to take them out of there, or we need to change some things now that I've thought about it a little bit further. So it takes the pressure off of making a lot of those changes and stuff. But basically, we do everything in life. Well, let me say this first. I always like this slide. You do get what you pay for. I will not regale you with the hours of stories I have with people who've tried to do their own estate planning documents that have just completely ravished their otherwise what they thought was going to happen. You can tell they did the exact 180 of it. People trying to do their own wills, powers of attorney, not using certain words, language. In our field of practice, words matter. And unfortunately, you won't be here at that point in time to tell the court, this is what I meant, or this is what that should have looked like, court. And if you can't have evidence to tell what the court meant, a lot of times it's not going to work how you wanted it to. And you could have been a lot better off spending money to get your plan done correctly so that it works correctly, so that you can have some peace of mind about it. We do, when we're doing a trust portfolio, we do a trust that's a joint trust between you and your spouse, or if you're just a single individual, the price for that is $64.50, and that includes 1 deed fee. If you have more than 1 piece of real estate, say an investment property or a vacation home or something, we do incur another deed fee in that part of the process. But other than the joint trust, and what sets our firm apart is that we're going to help you connect all of your assets to it. A lot of firms that set up trust plans do not do that aspect of it. And I dare say that's the most important part of it. It is very difficult in connecting your assets to your trust due to many changing institutional processes, seemingly week to week, month to month, and or the forms that they require to do that. It's our job when you take us on, that's part of our fee to do that. So I would encourage you, if you're looking at other firms doing this, I highly encourage you to ask them if that is part of their process as well. And I would near say that most will tell you it's not. Okay. Along with that, you're also getting your pour over wills, your financial healthcare powers of attorney, advance directives, HIPAA authorizations, and many other items there. If maybe the trust package didn't speak to you, maybe if you're a younger couple or those fees are more than you can afford right now, at least a will package would give you something to have in place. And that still comes along with the will, your financial power of attorney, healthcare power of attorney, advance directive, HIPAA document, and estate planning letter. That's $2,200 for each person. At the end of the day, we just want you to have options as far as certain things that can help you or your family. And certainly everybody's estate, family dynamics, and again, goals are different from one family to another. So needless to say, I just don't want you to put your head in the sand because it's very easy to do. This can always be on your next year's to-do list, along with your other New Year's resolutions, as I like to say. So you've earned it sitting through this. You've got a free consultation with our attorney at our office. We also offer Wisdom Well Care meetings, which is our financial planning arm. If you do not have a financial planner, or maybe you'd like a second opinion on that. Again, please look at our Calendly link and you can see what availability we have of appointments in there. My only conditions on those are that they must be within 2 weeks, because I oftentimes find that information is lost between those time periods. If you are married, both people must be there. Let me say that again, because I do have sometimes spouses that like to come without their other spouses. I'm not sure what that's about, but if you're married, both spouses must be able to be in attendance. And at the end of the day, we just need to know if we're going to be a good fit to work together, a simple yes or no, and that's completely fine either way. Please don't come in and see us if you're not serious about moving forward with the estate planning, or maybe if you just had a question or something of that nature. If you want to talk to somebody, say about construction law or a civil issue or maybe a traffic issue, obviously we don't do those kinds of areas of law. So I just don't want to waste your time and have to refer you out to somebody else. But needless to say, I hope that you got some information out of this. I hope that you can share this, even if it didn't resonate with you, maybe with a parent, a friend, at a civic club, at a church, synagogue, wherever you're at. What I would say is hopefully you have a plan in place already. I would encourage us to let us take a look at that and make sure it's still meeting your goals with different law changes and everything else. And we hope that otherwise that you're staying safe and having a wonderful year otherwise. So at this point in time, what I'll do is I will take any questions from the group and hopefully we'll get those answered. But otherwise, we hope we see it in the office very, very soon.